Ladies and gentlemen, good day. Welcome back to the Indie Zone. My name is Kathy, and today's episode is all about discovery in Idaho versus Koberger, and specifically regarding a document that was filed by the court on May 11th, 2023, and a document, one of two, dealing with discovery that the state of Idaho responded to the following day, May 12th, 2023. We're going to address the second filing of May 12th, 2023 by the state of Idaho in the next episode. But what did the court do on May 11th, 2023? They set the defense's motion to compel discovery for hearing via Zoom to occur on May 22nd, 2023. The matter before the court is motion to compel discovery. Time 11 a.m. on the 22nd is when this hearing is going to be called up before Judge Megan Marshall. And all of the Zoom details are provided right in this notice of hearing. The second document that I wanted to address today is now that this hearing notice was filed on May 11th, the next day, the state comes back and responds to the defense's motion to compel discovery. It is state's response to defendant's third supplemental request for discovery. And what they do here is what they have done in response to all of the prior supplemental discovery requests. Recall, we are now on the third with respect to the defense. State incorporates the January 21st, 2023, quote, state's response to request for discovery, end quote. February 21st, 2023, quote, state's response to defendant's first supplemental request for discovery, end quote. And March 29th, 2023, state's response to defendant's second supplemental request for discovery, quote unquote, as if fully set forth at this point. The state has and will continue to provide discovery in accordance with the applicable rule of court and applicable law. What does this mean? Well, what's discovery? Discovery is evidence that one party feels the other side has in its possession, custody, or control that one party feels is relevant to the case before the court, whether it is criminal, as is this case, or civil. So Mr. Koberger is asking for evidence that he believes is pertinent to his defense that the state has in its possession, custody, or control. As this response says, this has occurred 3 times before. There was initial request for discovery, a first supplemental request, a second supplemental request, and now a third supplemental request for discovery. And what Idaho is basically saying here, in my opinion, is what they've done before. Defense and judge, we believe that we have provided everything responsive to what the defendant has asked for. Absent objections, you can raise objections to discovery, which they have. But if we find that anything further comes into our possession, we will comply as we are required to under applicable law. There's an additional matter that was filed the same day on discovery that we're going to address in the next episode. If you'd like to see these 2 documents, as always, I publish a link to the public docket in Idaho versus Koberger. As always, these are my opinions. And as always, I thank you for joining us here today.